Welcome to Jackson Lewis's podcast, We Get Work. It is our job to help organizations develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question, how does that impact my organization? The Department of Education has rolled out guidance on how it plans to enforce President Trump's recent EOs regarding unlawful DEI. Although the guidance provides education institutions with some information regarding how to comply, many questions remain unanswered. On this episode of We Get Work, we discuss the most common issues raised in the new Department of Education FAQ document and Dear Colleague letter, and explain what proactive actions higher education institutions can take right now and why. Our hosts today are co-leader of our education group, Monica Caterpaul, principal in Jackson Lewis's Chicago office, and Chloe Carpentier, associate in the firm's Cincinnati office and member of the group. Monica and Chloe, the question on everyone's mind today is, what do employers and administrators in higher education institutions need to know to comply with new Department of Education guidance, and how does that impact my organization?
Thanks, Alicia, and welcome everybody to the next installment of Jackson Lewis's Higher Education podcast series. In this one, we are going to talk about the FAQs, the frequently asked questions, that the Department of Labor issued a few days ago, which sort of follows up to what we call the Valentine's Day Dear Colleague letter that came out earlier in February. My name is Monica Caterpaul. I am a principal in Jackson Lewis's Chicago office, and I also serve as co-chair of our higher education group. And with me, I will let Chloe introduce herself as well.
Hi, my name is Chloe Carpentier, and I'm an associate in Jackson Lewis's Cincinnati office, and I am a member of the higher education group.
So Chloe, I hear you have a whole bunch of questions for me, and I'm really hoping I'm able to answer them. Information's coming out fast and furious.
Hoping to keep you as busy as this administration is keeping us. So.
Yes.
So, Monica, could you just tell us a little bit about the Dear Colleague letter that came out on Valentine's Day?
Sure. So the Dear Colleague letter focused on Title VI, actually, which prohibits race, color, and national origin discrimination for institutions receiving certain types of federal funding. So it didn't focus on the gender identity issues that we had previously seen coming out of the administration. It mentioned a whole variety of things that have to do with higher ed. So admissions, financial aid, scholarships, prizes, discipline, housing, graduation ceremonies, and then the employment side too. So hiring, training, promotion, etc. It talked about programs that the administration considers what they call smuggling in racial stereotypes, and a number of specific practices that they are deeming to be unlawful DEI in violation of Title VI. But that was really where the focus was.
And was there any fear from any of our clients or just, higher education in general when this letter came out, or what were the thoughts? What were the concerns about the letter?
The letter said that additional guidance will be coming out, and it also said that suggested that certain enforcement actions may be taken within approximately 14 days. So that brought us to February 28th or March 1st. And this FAQ is one of the things that came out as a result. So a lot of schools were taking stock of where they stand on DEI issues, generally across both employment and the student side, to see if they were compliant and that their practices aligned with their risk profile.
So ultimately, the FAQ that came out on March 1st, that was helpful?
Yeah, I'd say so. So this isn't new. The first Trump administration actually issued FAQs, on occasion as well. And it was helpful because there did seem to be a little bit of tension between the law in some respects and the Dear Colleague letter. And this definitely offered a little bit more information there.
And in the FAQ, did you see any themes within it? Was there anything that really stood out to you?
Yeah, there are a couple things, and they do go deeper than the Dear Colleague letter. So that was helpful. But as in all things legal, there's plenty of gray areas still.
It depends, right?
It's why we have jobs, right, Chloe? So one thing that struck us, which is not really surprising, is that there's a theme that everything is very case specific. The department is really going to look at each individual instance, the facts of each individual program or policy or situation, and make a determination as to whether Title VI was violated under those circumstances. But there were certain things that were definitely unlawful, right? And this is, pulling from the language of the FAQ. Some things that they consider segregation, so different housing or programs or graduation ceremonies where people are separated out, even voluntarily, by race, national origin. And then the things that they called veiled discriminatory practices. And then there was definitely an emphasis on First Amendment speech issues.
So it kind of sounds to me like there's some stuff in there that, has kind of been the standard for a long time, and then some new stuff then.
Yes, I think that's fair.
And with that being said, something that's new is kind of, after the Students for Fair Admissions court case, the essay loophole, or what the FAQ is calling the essay loophole. Could you talk to me about that?
Yeah, it's not really surprising that they addressed this in the FAQs because there did seem to be some tension between the Students for Fair Admissions decision and the Dear Colleague letter. So the essay loophole is Students for Fair Admissions said, and this is a quote, "Nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university." And that's what's called the essay loophole, according to the FAQ. But then on the other hand, the Dear Colleague letter seemed a little critical of using essays. And it said, and this is also a quote, "A school may not use students' personal essays, writing samples, in participation in extracurriculars or other cues as a means of determining or predicting a student's race and favoring or disfavoring such students." And so you've got on the one hand, Students for Fair Admissions saying, maybe you can consider essays, and then the Dear Colleague letter saying, on a very surface level, no to the essays. So which one is it, right? Obviously, that was an oversimplification, but there were some gray areas. The FAQ says that you can't craft essay prompts in a way that requires applicants to disclose race. And you can't also hold interviews just to visually determine an applicant's race. And those are pretty direct ways of using those things as a tool to make a decision based on race, which is unlawful. So the FAQ then goes on to say, schools, this is a quote, "Schools can credit what is unique about the individual in overcoming adversity or hardship, but never the person's race." So there's still some gray area left here, right? What if an applicant's race is fundamental to what makes them unique? Or what if their race or national origin, what if that is the adversity or hardship they had to overcome? So these are gray areas, right? And again, that means it's going to be a fact-specific inquiry still.
So I guess kind of moving on from admissions, because there was a lot in this FAQ.
Yes, there was.
Could you kind of touch on, any regulations or any sort of guidance on how teachers are conducting classrooms and just, what they can and can't teach? Did it touch on that at all?
Yeah. So just on like a basic level, there are, certain concepts like, obviously the First Amendment, especially in terms of public schools, but also this concept of academic freedom, which means that the government and even institutions shouldn't be interfering with the substance, sort of the meat of what faculty teach, what teachers teach, or what they research. And then there's some guidance also that says that the Department of Education itself cannot have, interfere with with that stuff, with the curriculum. But we do see some threads in this FAQ that again lead to more gray areas. So one thing is the FAQ calls out social emotional learning and culturally responsive teaching as potential areas where, where protected categories under Title VII may be implicated. The FAQ does say that it depends on, again, the specific facts, but those are areas, curriculum that, schools should be taking a harder look at. And then there's also the First Amendment issue. So as far as curriculum goes, there is a specific carve out in the FAQ for First Amendment issues and for those prohibitions on the Department of Education from exercising control over curriculum. But it does also say that the First Amendment and those curricular protections don't relieve schools of their Title VI obligations. Now, that's true. But you also sense a tension there. And the first Trump administration's Department of Education also looked at those curriculum issues. So this is not new, but we do see an increased focus here. And we may see, content-based challenges, maybe litigation, depending on how the Department of Education takes action. But the fact that those topics were called out here means that the department's probably going to be looking into it more.
Well, I guess speaking of something else that's kind of, in the forefront of education is, being at school and then seeing a protest go on or partaking in a protest. And it kind of looked like the FAQ was touching on that a little bit.
Yeah, not just the FAQ. Some of you may have seen what President Trump posted today, March 4th, on Truth Social, and it specifically talked about protests on campus. And you can take that to mean that, this is on the administration's mind. And given that and what's in the FAQs, it's something that we can expect to see some action from the Department of Education on. But beyond that Truth Social post, the FAQ also specifically mentions protests multiple times. And it is sort of hearkening back to those campus protests regarding the war in Gaza and also how those congressional hearings went last year. And the FAQ says you can't discriminate in how schools can't discriminate in how they discipline or sanction students in response to complaints or harassment. So in other words, say there's a protest and the students on the other side are complaining that the protest constitutes unlawful harassment based on their race or national origin. It doesn't matter what side of the spectrum they are, the discipline or sanctions, if it is harassment, need to be the same. So that is the law. That's absolutely correct. But you can see how there could be gray areas there, right? And overall, it does show the focus. I mean, our recommendation is that schools really reassess how they deal with issues that trigger free speech. And there will probably be more investigations, and you could probably expect the Department of Education to take pretty expansive views on the case law as is suggested by this FAQ.
And, if a school has any question, they can reach out to a Jackson Lewis attorney.
Yes, they can.
For more advice.
We are deep in it every day.
But I guess, so to kind of tail off of that, we've talked about a lot that has changed or how we're kind of seeing this administration change its approach to regulating schools or attempting to regulate schools. With that being said, what's still okay?
Yeah, the one thing that it does still say that educational and historical observances are okay, which is helpful because there has been some question about can schools, employers, institutions across the board celebrate Black History Month, Women's History Month, International Holocaust Remembrance Day, things like that, Pride. What the FAQ says, and this is consistent with Attorney General Bondi's memos that came out last month, it's fine as long as those celebrations are celebrating or recognizing historical events or contributions to a field, or just promoting awareness of those historical events or contributions. But those celebrations would be a problem if they discouraged students or employees of a certain race or national origin or ethnicity to participate, or somehow created a hostile environment based on race, national origin, or ethnicity.
Okay, so let's get down to the nuts and bolts of the FAQ. If I were in a school administration, what should I know? What would I want to know?
Yeah, there is some, relatively structured guidance here as to how they're viewing things and how they'll proceed procedurally. So one thing that the FAQ says is that the Department of Education is looking for, this is a quote, different types of circumstantial evidence that taken together raise an inference of discriminatory intent. So that harkens back to a Title VII convincing mosaic standard. And they also apply a 3-step test, or they say they will apply a 3-step test to decide if any particular practice is unlawful. So first, they will ask, did a school treat a student or group of students of a particular race differently from a similarly situated student or group of students of other races? Second, if so, can the school provide a legitimate non-discriminatory reason for the different treatment that isn't pretextual? And pretextual has historically been construed as sort of a false statement, an intentionally false statement, something that isn't true. And number 3, finally, if the school is unable to offer a legitimate non-discriminatory reason, or if the offered reason is found to be pretextual or cover for discrimination, OCR will conclude that unlawful discrimination has occurred. So that's sort of the 3-part test. And then there are some particular things that they called out as well.
And what are some of those particular things? I think if I remember correctly, it was specifically for universities.
Yeah, this is all specific for universities. And it's interesting because a lot of this, the language focuses on students, but we may see the same sort of theories applied to employee populations at schools as well. But there were 6 things that were called out that they're really going to take a look at. So first, whether members of a particular race are treated differently than similarly situated students of other races. Pulling again from, a very classic discrimination standard under many areas of the law. The second, the historical background or administrative history of the policy or decision. And then, for example, and this is just speculation on my part, but the Dear Colleague letter referenced the use of standardized tests as a proxy or a means to build out a more racially diverse student body. And maybe you'd look at it and say, well, those standardized tests actually were left over of COVID. So the historical intent or practice was actually a COVID-safe protocol and not an intent to change the makeup of the student body, just as an example. Number 3 was whether there was a departure from normal procedures in making the policy or decision. Number 4 was whether there was a pattern regarding policies or decisions towards members of a particular race. Number 5 is that they'll look at statistics that may demonstrate a pattern of a policy or decision having a greater impact on members of a particular race. And number 6 is whether the school was aware of or could foresee the effect of the policy or decision on members of a particular race. And those last two, with those two, schools should really think about whether a disparate impact theory could also be applied to their practices as opposed to just a disparate treatment theory.
I guess with that being said, the disparate impact theory in the education context, that's new, right?
Somewhat new. There are certain areas where disparate impact can be applied. For example, definitely under Title VII. Under Title VI, it can be applied by administrative agencies, but there's not a private cause of action. So it's complicated. Like all things, you're sensing a theme here.
It depends, right?
It depends. 3 years of law school, and that's what we came back with. It depends.
I guess with that being said, now what happens if the administration comes to a university and says, okay, we've decided that there's a problem?
Yeah, according to the FAQs, first they're going to contact the school and they're going to see if they'll enter into a voluntary resolution agreement. So that'll have specific remedial actions laid out and then some sort of monitoring plan for the implementation of those actions. If the school refuses, it says that it may result in OCR initiating enforcement or referring the case to the DOJ. Those are quotes. Now, it's interesting because it doesn't mention revocation of funding. That's probably because it's really not easy to revoke funding. It's a long process, but that's always floating out there. One thing that's really interesting, though, is that the case processing manual was actually updated in February of 2025, so just last month. And we're in the process of digesting it, but that could impact the process that they apply to revoke funding. And it does have some specific mentions that mirror some of the topics that were addressed in the Dear Colleague letter and in these FAQs. So stay tuned for more on any changes to that case processing manual. We'll be on top of that as well.
And I guess to just kind of end on, a little bit of a different type of question.
Sure.
But the Dear Colleague letter and the FAQ, are those laws?
No, they're actually not laws. Good question. They are guidance and they reflect what the Department of Education's interpretation of laws will be and the types of enforcement actions that they will take, but they're not actually law and they're not actually binding. And that's why, unlike in many other areas where we have seen litigation against some of the administration's actions and even temporary restraining orders that have been issued, for example, against one of the executive orders recently, there's not a whole lot of specific litigation about the Dear Colleague letter or about the FAQ because there's a standing problem because they're not actually enforceable in and of themselves as law. We'll just have to see how the Department of Education rolls out its investigations, its enforcement actions based on what we have read so far.
And I guess with that being said, stay tuned for our next episode.
Yes, we will continue to do this. We're planning to roll out higher education and sometimes K through 12 as well, specific, podcast, at least every couple weeks. So check in and stay tuned.
Awesome. Well, Monica, thank you so much for your time.
Thank you. It's fun to talk to you as always.
You too. All right. Have a great one.
Thanks, you too.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.